nuisance law typically involves a situation where one party is doing something with their property that, for one reason or another, turns out to be offensive to a neighbor. Today, we're going to be talking about an aspect of property law that involves nuisance, which is a topic that is very near and dear to the hearts of many New Yorkers. There are lots of different ways a nuisance can be created. In fact, just last night, around 3 in the morning, I woke up because some couple had somehow not gathered the spirit of Valentine's Day and found themselves fighting outside of my apartment, which sort of made me think, wow, public nuisance, private nuisance, how should the law deal with this problem? And then I thought to myself, I can't wait to tell my class tomorrow. Property, just in general, is really a course about how to regulate human behavior in relation to what people own and what people do with what they own. We could probably assume that maybe there's some sort of clear relationship between the two houses somewhere around here, right? And that would involve the idea of the wall, right? And the wall that causes all the problems, right? So let's just put the defendant's house somewhere here. Now, when was the defendant's house built?
In 1912.
Okay, good. So what does that tell us?
That the plaintiffs, they knew of the wall when they moved in.
One of the things that you'll discover about property, if you've not already discovered this, is that it also involves the experience of learning how to live in a community of people. So they buy this house, right, and they start realizing, right, that the wall under their front porch is giving way, right, and the living room plaster had cracked. Now, these are very smart people, right? They realize that in order for there to be some sort of deterioration in their structure, it probably might make sense to explore the possibility of blaming another party. The nuisance law, which is what we'll be talking about today, is a really big part of that. And the question often involves how far the law should get involved. Now, how in the world do the plaintiffs wind up constructing an argument that successfully blames the defendants for what's going on with their porch and the plaster? What do they argue?
Well, they argue that Ms. Price has the duty to, because she knows of the purpose of this wall, she has the duty to maintain the wall, that she's inherited this duty from the people that owned her house previously to maintain the wall based on this idea that you have a duty to not undermine the lateral support of your neighbors.
Okay, good, good. The idea here, when we focus on the wall, right, is that it's a support wall, and that this wall is a very important source of support for the plaintiffs, right? Because if that wall remains sort of unrepaired, plaintiff's house starts slowly slipping down the hill, right? So here, the defendant argues that the plaintiffs were essentially negligent, right, in protecting their own party, right, and that they actually couldn't sue her because it was the predecessor and not her that was responsible. Real property is about land. It's not about structures, right? And so if we're crafting natural rights, really strong absolute rights, it makes sense for us to start from that place where we're really thinking about the natural rights and not necessarily from starting from a place where we really want to value the building of structures over the natural sort of state of the land. The kind of key black letter rule is the idea that owners who withdraw lateral support for neighboring land are strictly liable for any resulting damage to the land in its natural condition.